Please be seated. We'll hear argument in 23-525, Moore versus Wells Fargo Bank.
May it please the court, Mr. Jackson will present argument for the appellant. Appellant has reserved 5 minutes for rebuttal.
May it please the court. Before the court today are two certified questions from the Fifth Circuit Court of Appeals. The first is, may a mortgage lender simultaneously rescind a prior acceleration of a mortgage loan and re-accelerate under Texas Civil Practice and Remedies Code, section 16.038. The second is that if the lender cannot simultaneously rescind a prior acceleration and re-accelerate the same loan, does that void only the rescission or the re-acceleration? To address the first point, we have to look at what the statute says. The statute says under 16.038 that a lender may rescind a prior acceleration of a mortgage loan if he gives written notice of the waiver or rescission of that loan. At the outset, this court, in answering the first question, can look at the notice that was given to the borrower, which I've provided to the court in my sole exhibit, and the court can conclude, based on the title of that notice alone, that it was not an effective rescission of acceleration in compliance with the statute. The title of the document is Notice of Acceleration, the very antithesis, the very opposite of the thing that the statute says that the lender can effect. A rescission of acceleration is what the statute allows, but the title of the notice is an acceleration. Within the written paragraphs of this notice, there's buried in the fourth paragraph language suggesting that the lender was abandoning or rescinding the prior acceleration under the statute. However, the court should not give effect to that language because the overarching point of the letter is to accelerate the loan.
So if they had done one, if they, before breakfast, put in a notice that was a rescission, and then at lunch put another notice in that said acceleration, would that be okay?
No, I don't think it would be okay.
Why?
Because, and this gets a little bit into the second certified question, because the law has been, for decades, since it was found an equitable requirement under the common law that a notice to accelerate be preceded by a notice of intent to accelerate. The Fifth Circuit looked at this question in the Robb case and
Okay, so let me try again then. Breakfast, rescission; lunch, intent to accelerate; dinner, acceleration. Solve the problem or not?
Well, in addition to that being practically impossible to affect such written notices in the timeline that you suggest, and I've never seen anything like that in all of my years of experience in practicing in the foreclosure defense arena. I don't think that are you asking in general, or are you asking in regard to?
For you, maybe that's what people start to do, and so maybe you haven't seen it, but if we say no, they have to be completely separate things, and they have to be done in a sequence, I guess what I'm trying to find out, is there any particular time in between these steps that's required or not?
The statute itself implies a period of an unaccelerated loan.
How much of that is that period? What is there some basis to think, for example, that the targets of the acceleration must have time to cure, some amount of time to cure before the acceleration happens? Is there some basis for thinking that? Could that be a predicate for finding there to be something more than just this every hour you send to the next one, or not?
What comes to mind for me is there's a statutory requirement for principal residences for the lender to send a 30-day cure letter, that they have to provide the borrower, the homeowner, 30 days to cure the default. And typically, the way it works is the notice of default under Chapter 51's non-judicial sale requirements is the same as the notice of intent to accelerate, which is required by the common law.
Is the notice of intent to accelerate applicable in this case? Because wasn't there something in the loan documents that waived notice of intent to accelerate?
So my first response to that is not a question before this court. This court's duty in answering the certified questions is to answer the certified questions and not to go into the facts or to the details of this waiver argument that they briefed. And I pointed out in my response, that's the first time, in this court, that's the first time they have ever made that argument. That was not an argument made in the federal district court, nor in the Court of Appeals. So it's not something this court should even consider or can even consider.
But if we did you waive it? I mean, is it waived in the loan documents or not?
So the law is the foundation of that ability to waive a notice of intent to accelerate within the loan documents that is established under Texas law. In this particular instance, I cannot concede that my clients waived the right to a new notice of intent to accelerate. That is not an argument that was made. It's not something in the record, and it's not something within the province of this court.
Well, the Fifth Circuit always disclaims that we have to confine our response to the precise question certified. So if there's a foundation for it in the law and it hasn't been disputed, did it need to be briefed before? If it's not disputed,
I think it did need to be briefed before. It has to be something that the Fifth Circuit can have in its argument, something that it can rule on, an argument the parties have made. It was never presented to the federal district court. It was never presented to the Court of Appeals. And the Fifth Circuit Court of Appeals did not present that question to this court. And so while they disclaim that you ought to narrow your ruling specifically to answering the certified questions, I do not believe that disclaimer rises to the level of this court being able to make decisions on the merits based on an argument made for the first time in briefing in this court on a certified.
The Fifth Circuit's perfectly capable of deciding that the waiver argument has in fact been waived. But we're answering legal questions, and so if this is something that frequently happens, it doesn't seem like it would be crazy for this court to at least address it, with the Fifth Circuit being perfectly then free to say, that's great, but it won't apply here because it was a forfeited or waived argument. But just on that understanding, if this were a different case and it had been addressed in the lower federal courts, is it something that would make a material difference to the questions that I had asked about the sequence and the number of things that have to be presented?
I think we have to focus on the simultaneous action here.
Well, in looking at that, potentially there may be any number of reasons why the subsequent acceleration is ineffective. The notice was supposed to have been given, the loan documents didn't waive it, it wasn't raised. Any number of reasons why the purported new acceleration may not be effective. But what we're asked to focus on is the rescission of the earlier acceleration. And how would any of those kinds of considerations impact under the statute, the rescission of the earlier acceleration? And there's a calculation of a new maturity amount and all of that in connection with these multiple notices.
So no reasonable borrower looking at that letter could reasonably interpret that as a rescission of acceleration, because there was no point in time where the loan was actually not accelerated.
Even with new calculated amounts due and owing and that kind of thing. I mean, there are some differences in the notices. They're not they're not cookie cutter.
There are some differences. That's true, Your Honor, but each one of the 4 notices simultaneously rescinds and reaccelerates, and the court should focus on what that means to the borrower. A borrower reading these notices is under the constant threat of foreclosure, but the fact that they're never in an unaccelerated status leaves them in limbo. They're uncertain of their workout chances. They're uncertain if the notice is going to come for the next month. Texas only has a 21-day sale notice provision. So they're constantly wondering, is this going to be the one? Is this not going to be the one? No one would think, oh, I'm breathing a sigh of relief because now my loan is not accelerated, and now there can be given effect, this legislative intent of me trying to work out my situation. It's completely flouting the legislative intent to give the borrowers some respite, to give them some certainty. Okay, I'm safe not just for 21 days, but now I'm safe until I at least get a new notice of intent to accelerate, when I have to start making my plans again about how I'm going to conduct myself and how I'm going to live my life facing foreclosure. That's what this simultaneous rescission and reacceleration, it's this disparity of power that's just magnified by this practice. And it flouts the legislative intent. It doesn't give the borrower any respite or any hope. It just puts them in a continued state of uncertainty. To allow them to oscillate between rescinding and reaccelerating, it also completely flouts the purpose behind the limitations period to begin with. You want to bring finality to the situation. I'm not saying somebody wants to get foreclosed on, but I can certainly imagine a situation where you would want it to be over, one way or the other, not under this constant cloud of rescission and reacceleration simultaneous, where you just don't know what's going to be happening next. And also, of course, the policy to terminate stale claims. You can't have a situation where the bank is allowed, based on completely on its own decisions, that it's going to perpetually keep a loan in a state of maturity well past the 4 years that they're supposed to act after first maturity. For them to, for their own business decisions, play with borrowers like toys and say, well, I'd rather just keep them over there wondering what's going to happen because the market's not right to put so many foreclosures on in Harris County right now. That shouldn't be the way this process works.
There's some benefit to the borrower of that too, isn't there? If you can get a higher price at the foreclosure sale because the market's better, isn't there value to the borrower as well as the lender?
Well, so the Aston court pointed to the fact that the borrower gets to stay in the house.
Well, there's also, at least theoretically, some value to that as well, tempered by all that you've just highlighted. But I'm just saying, if you're talking about using them like toys and all that just for business purposes, but if the thought is, look, we don't want to put another foreclosure on the market and have to sell, now because the market's just so bad, if we can hold off, well, that's going to benefit the lender, of course, but isn't there also some benefit to the borrower for that?
There's a hypothetical benefit.
How is it hypothetical if the deficiency is less?
Well, so if the property that's cried out at the foreclosure auction, if the bid is higher than the credit bid of the lender, then it would result in excess proceeds that could potentially be available to the borrower after payment of all of the junior liens. But that's completely hypothetical because it depends on somebody being at the auction bidding over the credit bid. And frequently what you have with distressed homeowners, depending on market situations, but if they've been in distress for a while, they're typically underwater. So for an underwater homeowner, there's no benefit because no one's ever going to bid above, no third party's ever going to bid above the credit bid. And so while while it's hypothetically possible that them waiting to do the foreclosure could result in could result in excess proceeds, it's completely dependent on too many speculative factors for it to factor in this court's decision-making.
For this first question the Fifth Circuit asked us, I'm still trying to figure out why it can't be simultaneous. It seems like there's two things. One, a very technical argument, your bench book, it doesn't seem like, it seems like it's mostly about acceleration. You can't put them in the same form when it's not clear. I get that. That's one argument. The other argument could be, well, they can't be simultaneous because there actually has to be a substantial delay between them. And that's the part that I'm trying to figure out what that is, why it is, how long it is, and what basis you have for that.
Yes.
I'm not sure I really understand what your second argument, that second point is.
So the statute says that
As in the future,
it says in the future. So within the statute itself, it implies some period of time. So I would just simply say not simultaneous.
but okay, so we're back to my thing. Can you put it in the mailbox? Maybe if you don't think it should be done at each meal of one day, how about the morning of 3 subsequent days? Is that enough? Give me something to be able to understand what in the future means that's meaningful. You mentioned the 21-day period. You mentioned the cycle of billing. Is there something in our common law precedent or the way the statutory scheme works that gives somebody an entitlement to try to cure before anything that you can give us about what in the future means?
I'm unaware of anything in the common law that provides any kind of necessary time frame. The Holy Cross Church of God case is probably the one case you go to look at for the steps needed. I don't recall anything in Holy Cross Church of God that says the notice of intent to accelerate has to precede the notice of acceleration by X days or I don't even think they say reasonable time. I think it's just a sequential.
So can I just get you to agree then that if it happens, I put the first one in the mail on my way to work on Monday, I put the second one in on the way to work in the mailbox on Tuesday, and the last one on the way to work on Wednesday, that would satisfy our law? Is that your position? And this one didn't because it was all in one document?
I would say yes, subject to the requirement of the 30 days from Chapter 51 for principal residences.
Okay.
Any other questions? Thank you, Mr. Jackson. We'll hear from the respondents.
May it please the court?
Appellees.
Mr. Durell will present argument for the appellee.
Mr. Chief Justice, and may it please the court. The court does not need to answer the first certified question to resolve the parties' dispute in this case. The dispositive issue
But
here.
our job is to answer the certified question, not to resolve the dispute.
That's correct, Justice Bland. But there's a question that can be answered that would resolve the dispute within the context of the questions asked. And so the question is whether the lender effectively rescinded the acceleration in this case, because the acceleration portion of it is not relevant in this case, because this is a pre-foreclosure matter. And so whether the lender effectively accelerated the loan is not at issue here. The question is the notice compliant with the statute? And the court can look at the notice, and it can determine, just like the district court did in this case, and like the Court of Appeals did in, the First Court of Appeals did in Aston, in PH Mortgage v. Aston, and determine that it's written, it's a notice, and it states that the lender hereby rescinds acceleration. And that's all the statute requires. Those courts address that in 2 sentences in addressing this issue, and the court could do the same here.
Would it matter if it was a 60-page letter with all sorts of things about real property rights, and then on page 47 there was a little notice of rescission? Would that make a difference or not?
It would not, Your Honor, not based on the plain language of the statute. Nothing in the statute requires the notice to be in any particular form. Nothing requires the notice to have any particular title. Nothing in the statute prohibits the notice from including any additional information.
So make it 500 pages, and you get all these things with your credit card and all that kind of stuff, and they've got these little itty teeny bitsy footnotes and things, and it was all in footnote 212 in this real thin onion paper thing. Same answer. Hey, statute doesn't give any requirements at all.
If the court is going to apply the plain language of the statute, yes, it would be the same answer, because it is written, it's a notice, and it states that the lender hereby rescinds acceleration. It must be properly served. That's not an issue in this case. It's simply, does this document comply with the statute?
Is
And
it really
does.
a notice at that point? You said it's a notice,
Correct.
but in footnote 212, is it a notice?
If a notice
What
is
does that
simple-
mean to be a notice?
I would say that a notice is notifying a party of a particular act. And so if a notice is simply a document that says, the lender hereby rescinds acceleration, that would be a notice of a rescission. There's a notice of rescission within that particular document.
What if it's in Portuguese?
That could be an issue. I'm not
Well, it's in writing, I mean,
correct, but there could be some other statutes that I haven't considered that might actually require it to be in English. That
Or if
could
it's
come
in a
into-
code, but they give you a key to decode it?
Little
That-
orphan Annie and her,
if you're applying the plain language, if the borrower could actually decode the message, then potentially there's no issue. Could that be something that is deceptive and kind of flouts that line? Probably. But obviously,
that we want to answer the question that they asked instead of go down this path.
sure. And so the court can and it should answer the first question because it's important to provide clarity to the law. The first question requires the court to determine whether a lender is required to comply with a common law rule that requires that an acceleration be preceded by a notice of intent to accelerate. And there are three grounds that the court can rely on to determine that no such notice is required in a situation where you have a same notice rescission and reacceleration. First, the equitable principles behind the common law rule do not apply. Second, the right to reinstate, which is a contractual right here, negate the equitable principles that form the basis for the rule itself. And finally, we go back to the statute. Nothing in the statute says that this cannot be done, and in fact, there are provisions that support a same-day notice. So starting with the first ground, this court in Allen Sales Service Center versus Ryan traced the origin of the common law rule. And it stated that acceleration is a harsh remedy, and it is, traditionally, because it cuts out the borrower's right to cure a default. And this is harsh in the sense that the loan was originally contemplated to be over a course of several years, and now the loan will be immediately due. And so the court determined that equitable principles apply here, and that a borrower should be given the opportunity to cure that default before acceleration occurs. But in this case, with a same-day notice that requires a rescission first and then immediately followed by a reacceleration, the default that underlines the first acceleration that's being rescinded and the default that underlies the reacceleration is the same. The borrower has already been given notice of that default. They have already been given notice of the opportunity to cure, and they've had that opportunity to cure. This will be the case in every single situation. And the reason for that is that this would be a requirement to have an effective acceleration, the very first one that we're rescinding. And so in every single situation, there will be a notice, an opportunity to cure here.
So the 30-day period, you only have to do that once.
That's correct, Your Honor. And that statute does not require it to be done more than once. And there is no common law that I'm aware of that would require the lender to renotice default and the intent to accelerate. And so the rule is served. The rule has already been served in this situation, and it always will be served in this situation. And the second has to do with the contractual right to reinstate. Now, this is a contractual right found in the loan documents in this case. It's also very common, given that most residential loans these days are government-sponsored enterprises or backed by the federal government. The servicing requirements for these particular loans actually require that a borrower be given the right to reinstate even after acceleration. So what does that mean? Well, that means that this harsh remedy of acceleration isn't so harsh if there's a contractual right after acceleration to do what acceleration is supposed to say you can't do, which is cure the default. And so because that's present in this case, the common law rule requiring a notice of intent to accelerate does not apply. This negates the harsh remedy that that common law rule was seeking to remedy. And then finally, we turn to the plain language of section 16.038. And subsection D of that section confirms that a rescission notice does not waive a past default. So that tells us that default is still in play, the same default that required the original acceleration, the same default that would support reacceleration. It also tells us that it does not affect a lender's right to accelerate in the future. Now, what does that mean? Well, it's just an event that occurs after another one. Well, if you read a document like most Americans do, and you read it left to right, top to bottom, you will see that there's a rescission followed by an acceleration. The acceleration is in the future when you read the document. And Justice Young, you asked a question about if you do require that it not be contained in the same notice, well, when? Well, that's a good question. And the problem is an answer no to the first question would bring uncertainty and inefficiency to this process, because lenders wouldn't know is it just limited to the same, you can't do it in the same notice, or can you just not do it in the same day? Can you do it one day later? And as opposing counsel had admitted, there is no common law rule that would establish this.
Could we make such a common law rule?
The court could certainly make a common law rule. How the court would decide whether it's 1 day, 15 days, 5 hours, I'm not sure what would guide that decision.
What about the 21-day period for the sale?
So there is, under the statute, to have a foreclosure sale, you must post a notice 21 days before the actual date of the sale. But so the problem with that, if you have an intent to accelerate,
They're just mismatched. There's no particular reason why 21 would do anything magically.
there's not. And this,
What if we took the 30 days from the initial? I recognize that the statute doesn't, you have a good argument for why that wouldn't be required again. But if the legislature says in the future, well, that seems to suggest that the legislature at least did not expect it to be simultaneous, and might not have thought then that it could be something that is essentially simultaneous, like my, letter at breakfast, letter at lunch kind of thing. Would the 30-day period at least be somewhat tethered to something that we see in policy from the legislature that the legislature could change? You could always change the common law.
and so there is no 30-day period. I think opposing counsel misspoke. It's actually a 20-day period.
Or
The
whatever
minimum-
it is,
So
yeah.
the minimum is 20 days under the statute for a borrower whose, that the security is a home that is his principal residence, has a statutory right that cannot be waived to 20 days notice of an opportunity to cure. The court could potentially, adopt that, but that's something for the legislature to do, because the legislature did not
No, it's a
require.
tough thing because the legislature says in the future, and it seems like any of our hypotheticals collapse into either, well, we're going to erase that. There is no, that means nothing. Or we're going to start adding things to the statute without any particular strong basis to do so. And tell us how we choose which one is better.
And so the court can interpret in the future to mean not just the same notice. So the notice is simultaneous, and I think that's kind of the issue with how this question is phrased. It's phrased as a simultaneous rescission and reacceleration. But the notice might have been simultaneous. I mean, it's one notice, but the actual acts are not simultaneous. You can't do the same thing at the same time. You must read it as rescission and then a reacceleration. So it is in the future when you read the document, because it occurs, the act actually occurs after.
So if footnote 212 is the reacceleration, the rescission better not be in footnote 213.
That could be a problem. And so this actually gets to, the two aren't interdependent. You can have a rescission without a reacceleration, right? But you cannot have a reacceleration without a rescission. The rescission must come first. And so it appears that the way the Fifth Circuit drafted this question is that you got to have both, but you don't. One doesn't control the other. And that was the introduction to my argument is you don't really need to look at acceleration because, again, they're separate. They're separate.
If the
acts.
rescission is illusory, and it's just a total magic words formulaic thing that's just thrown in there, if it's really illusory in substance, then all it boils down to is giving you a unilateral opportunity to extend the statute of limitations. Is that right?
That's correct, and that is exactly what the statute allows. The statute allows lenders to extend the limitations period. And so let's look at this from a big picture perspective. What impact would this have? What impact does it have whenever a lender provides a same-day notice of rescission and reacceleration? Well, let's look at it from the borrower's perspective. They're in the exact same position they were in before receiving the notice, correct? The loan was already reaccelerated, they were facing foreclosure. After receiving the notice, the loan's accelerated, they're facing foreclosure. No different from the borrower's perspective.
Except that they're closer to the statute of limitations in one situation than the other.
And that's a good point, but let me explain why that doesn't control. This court provided in Jasper State Bank versus Braswell that the purpose of the statute of limitations with respect to real property liens is not focused on the mortgagee and the mortgagor. The statute's focus and the purpose of the statute is for third-party purchasers. And it does that by invalidating any liens where it's been 4 years after acceleration. And that is the language of the statute 16.035 of the Texas Civil Practice and Remedies Code. And this court addressed that in the Jasper State Bank case. And so the statute of limitations is a shield for third parties. It's not a sword for borrowers to escape repaying their debts in this particular instance. And the court can rely on that case for that particular point. I'd like to shift at this point to address the second question. Let's suppose the court says, no, you cannot have a same-day rescission and reacceleration. The court should still determine in the second question that an ineffective acceleration, if you will, does not negate an otherwise statutory compliant rescission. The court's analysis can begin and it can end with the plain language of the statute. And let's just quickly walk through it. Subsection A unambiguously describes the result of an effective acceleration. It tells us that a note is governed by section 16.035, the 4-year statute of limitations, as if no acceleration had occurred. We get to subsection B. It tells us what is an effective rescission. Well, it's a written notice of rescission, and it must be properly served as set forth in subsection C, which is by either certified mail or first-class mail. Subsection D tells us that a rescission does not affect a lien holder's right to accelerate in the future and does not waive past defaults. Subsection E makes clear that a rescission does not affect how or when a new limitation period begins to run on a reacceleration. So it tells us right there that section 16.038, the rescission statute, is not intended to determine whether a loan has been reaccelerated or not. Reacceleration is not relevant under the statute. All you need to do is look at the plain language of the statute and apply it as written, as this court generally does in situations like this. There's no ambiguity.
So your argument that you opened with about we don't need to answer whether it was accelerated again is really saying just answer the last part of question 2. Even assuming that there's no reacceleration, the rescission is not voided.
That's correct, Your Honor. And that's the way that the district court, in this case, reached the issue. That is almost the way that the First Court of Appeals addressed the issue in Aston in that case, except it went a little bit farther than the district court did. And the district court the First Court of Appeals addressed all of the counter arguments that were made by the borrowers in this case with respect to why a rescission notice is not valid if it's contained within an acceleration notice. But the court could go that way and not actually address the first issue.
Either party asked for certification, or was that something the court did sua sponte?
That is something that the court did sua sponte. It was a hot topic from the bench early on.
Because you didn't want to be in state court.
Generally, we prefer to be where we can win, and we can win in both state court and federal court. That just happened to be where this case resided. And
That happened to be where the case resided. What do you mean?
so that's where the case was. We were in federal court. We made it all the way up to the Fifth
You
Circuit.
weren't residing in federal court, you moved there. You literally removed to federal court, right?
I think in this case we did, Your Honor. I think we did remove this case to federal court.
Because you can't win in state court?
That's, I would say that's not accurate. I would say at the time, this would have been
Here you are in state court.
well, so we did win in state court, and you would find that the First Court of Appeals determined that we won in state court.
I
That's where-
appreciate your candor. You don't need to pretend that people don't choose their court based on how they perceive their chances of winning. We don't need to play that game.
I wanted to gently approach the topic. And so, in conclusion, the court should address the first question, and it can easily address the first question, and it would provide significant clarity with minimal to no impact on a borrower. Lenders would benefit because the purpose of rescinding is to ensure they have a valid lien. Borrowers would even benefit from such a situation because it means they could potentially stay in the house longer. There could be new programs that come that allow them to cure this default or allow them to modify their loan. Time is not a problem for the borrower. Living under this shadow of foreclosure really isn't an issue if you consider the alternative. I don't think any borrower would want to be foreclosed upon, would want eviction proceedings to happen, and would want to be removed from their property. Foreclosure is a last option for lenders. It's not profitable. A performing loan is profitable. With that said, the Appellees request that this court answer the first certified question. Yes.
Any other questions? Thank you, Mr. Durell. Jackson, you have 5 minutes.
The question was raised in my original presentation about what is notice? Or it may have been something you asked Mr. Durell, Your Honor. And notice has to be, in answering that question, I think you have to look at the document in front of you, and you have to look at it holistically. You cannot take one part of it in the middle and then say that the next part of it, which is the exact antithesis of what you just did, is somehow two separate notices. I think the court has to say this notice is either a notice of acceleration or it is a notice of rescission in compliance with the statute. I think it's obvious when you just step back and look at it holistically that this is not a notice of rescission. If you look at the language that Mr. Durell pointed out from the statute, as if no acceleration had occurred, that's the result if you give a proper notice. But this notice didn't create that. It didn't make that come into effect because it simultaneously re-accelerated the loan. So in addition to looking at the in the future language, if you look at the language as if no acceleration had occurred, that's in the statute, and it's undeniable that there was never a condition where the acceleration did not occur.
Do you agree that with what the other side said, that if we think the rescission was valid, that the additional invitation in the Fifth Circuit's question to say whether the reacceleration was valid is not actually relevant to the dispute y'all have?
I want to make sure I understand that question. If the rescission is invalid,
If the rescission is valid,
then the two-part question follows, or then the next question follows, is the reacceleration invalid or not?
I took him to say that second question doesn't matter in this case, even though the Fifth Circuit asked it. And I'm wondering if you agree that it doesn't matter in this case.
What matters to my client in this case is the validity of the rescission. If the rescission is not valid, then that eliminates the statute as grounds for them to claim that the 4 years didn't pass. As far as whether simultaneous action, if it's not allowed, voids both the rescission and the reacceleration, that's not an issue that would directly affect my client in this case. I think the Fifth Circuit asked it because they had that eerie guess in the Robb case, and they wanted to use the opportunity to get an answer as to whether they made the correct eerie guess or not in the Robb case, that the court should require, or that it is a requirement of Texas law to renotice the intent to accelerate before reaccelerating after a rescission or other abandonment. That leads me to the case of Swoboda versus Auckland Loan Servicing. So under the Code Construction Act, this court can look to common law corollaries to the statute. Before 2015, when the statute was in place, common law did provide for abandonment of acceleration, just another way to say rescission or waiver. And the Swoboda court and other courts I've cited in my brief held that reaccelerating an already accelerated loan is no evidence of waiver of acceleration. And the court can look at the logic of those cases, which held that from a borrower's perspective, this changes nothing for the borrower as far as the accelerated status. The court can look to that logic and apply it to the statutory corollary of 16038 and find that, indeed, it couldn't have been and was not the legislative intent to allow for the simultaneous action. Now, in the short time I have left, I'd like to address the equitable considerations on their argument about the requirement of notice of intent to accelerate being required after a rescission. It should be required. It's been in the common law for decades. Nothing in the contracts, none of the contractual rights, none of the statutory rights eliminate the severity and the harshness of the remedy of acceleration. And as you can see from the notices in front of you, many of them, or all of them, accompany a notice of sale with the reacceleration. So not only were they reaccelerating, but they were giving them the 21-day notice. There should be the requirement to avoid the harshness of the 21 days and to require a new notice of intent to accelerate after a prior abandonment, and that would also implement the legislature's intent to provide the borrower with as many opportunities as possible to avoid the foreclosure. So unless there are further questions, I would ask the court to answer that simultaneous rescission and reacceleration is not permitted under the statute, and that simultaneous rescission and reacceleration voids both the rescission and the reacceleration of the loan.
Any other questions? Thank you, Mr. Jackson. The case is submitted. That concludes the arguments set for this morning, and the marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.